call the second case on this morning's docket. Case number 113763, State of Kansas v. Richard A. Tracy.
May it please the court, I'm Heather Sussno with the Appellate Defender Office here on behalf of Mr. Tracy, and I would like to request 3 minutes rebuttal time, please.
3 minutes is granted.
Thank you. Just by way of introduction, this case started out as a probation revocation hearing. Mr. Tracy appeared at his probation revocation, and during the course of that hearing made an objection to 2 of his prior criminal history classifications that resulted in his B criminal history score at his original sentencing. The district court refused to consider that on the merits, saying that because Mr. Tracy had acquiesced to those convictions at sentencing that he could not challenge them now. He appealed from his probation revocation hearing and the denial of that motion, and we briefed at the Court of Appeals both the probation revocation and the 2 sentencing issues in this case, one of which involved the in-state prior Kansas burglary before 1993, and the other one of which involves a 1974 Colorado second-degree burglary. And at the Court of Appeals, the probation revocation was overturned, and Mr. Tracy was granted relief on the in-state burglary issue. The state filed a petition for review from those issues, or at least from the sentencing issue, and then we filed a petition for review from the Colorado burglary that we lost at the Court of Appeals. The state's petition was denied and ours was granted. In the meantime, both Wettrick came out and Mr. Tracy also completed his entire service of his sentence. And so in response to this court's show cause regarding the application of Wettrick, the state filed a notice of change in custody and argued mootness in their show cause response, and then argued that the changes to the illegal sentence statute also applied retroactively, preventing Mr. Tracy from getting relief. And so those, at this point in their show cause response, I don't think they even challenged the actual merits of the Wettrick application. I think it's just the sort of procedural things that we're here on this morning. So leading into that, I was going to address mootness first. I know this court had extensive conversations yesterday with the cases, which I watched, so I kind of was going to try to jump in and address some of the questions that this court had about this mootness question. And one of the first questions I think that was asked yesterday was who bears the burden on showing mootness? And I think the case law has not necessarily been entirely clear about that. I think it would be helpful if it was. Part of the problem here is that, well, let me give you my opinion first, and then I'll tell you part of the problem. Part of my opinion here is that if it's the party that's moving to sort of involuntarily dismiss the appeal, I think it's that party's responsibility to show mootness. Now, the obvious problem with that is that it's not terribly in the state's interest if they're the ones trying to claim mootness to find reasons to say it's not moot. And so you do end up with a situation where the defense is going to end up having to stand up here at some point and say, well, what about this? What about this? And I think the distinction is that the state still, I think, should bear the responsibility of, by clear and convincing evidence, proving that this issue is moot. And I think part of the problem in these cases is that they're so laser focused on the concept that under a motion to correct a legal sentence, which is essentially what we're under here because this was raised for the first time at a probation revocation hearing, that the only benefit that you can get from a motion to correct a legal sentence is a correction of the sentence. And I think that's taking things too literally. I think there are a lot of things, including the correction of a client's criminal history score and the classification of that criminal history, that carries through with the client even if the actual sentence itself has already run. And so,
but don't each of those problems, no matter what they are, and we went through, the gun-toting barber and all that stuff.
Yeah.
You heard all that,
right?
No matter what each of those collateral consequences is, don't they all have another solution
Well-
besides correcting the sentence?
And I guess one of the thoughts that I had when I was listening to that discussion yesterday was that at the point in time at which we're having a conversation about what other solutions the client could jump through, or what other hoops they could jump through in order to obtain those kinds of relief, particularly in this context, I think in our brief we raised the malpractice issue under Garcia v. Ball. I think the problem there is that you're sort of implicitly acknowledging that there is a prohibition that is already in place at that point, preventing the client from actively seeking that benefit. It's not a question of whether the client wants to file a malpractice claim, it's that the client is actively prevented from even meeting that threshold requirement unless this sentence.
How do we know that until that happens? And that, in thinking about how we talked about these cases yesterday, each one of these kind of speculative consequences hasn't occurred. Well, he might file a lawsuit, or he or she might want to become a barber, or he or she might want to possess a gun. None of those consequences has occurred yet. So, how do we deal with that? It's just all speculative. Every single one of these that is a collateral consequence of the illegal sentence that you're arguing. You might not even get relief, but if you did, it's just it hasn't happened yet.
Well, and I think I have two responses to that. First of all, I don't think it is speculative. Like I said, I think there's a difference between the question of whether or not the client can seek that, regardless of whether he ultimately decides to, whether or not that's a speculation as to whether or not he's actually going to follow through with that. There is a procedural bar in
Go file a
place.
lawsuit against his attorney in the future. There's nothing stopping that person from doing that, and until he's stopped from doing that, I don't see how.
But that's what I'm saying is I think he stopped from doing that potentially now.
Because
No
of the
one stopped
existing law.
because they're-
I'm sorry.
Excuse me.
Well,
No one
I-
stopped from filing. I mean,
Right.
you've heard this a million times, I know. You can sue anybody for anything, right? So no one stopped from filing, and you can always make an argument that the law is wrong or that it needs to be extended in a certain direction. That's all legitimate law practice.
Well-
So he's not stopped from filing a lawsuit. He may lose the lawsuit, but he's not stopped from filing it, is he?
Well, I think that if you can't meet that threshold requirement in Ball, that you have gotten sort of a declaration that your sentence is illegal, then I think you are prevented from even, you can technically file something.
You can
But
argue it's wrong.
you're not going to get past the summary disposition motion at that point. And I think that's
And again,
that's
you don't know that.
Well, and I guess this goes to my second answer to your question, which is that my client is in a slightly different position, I think, than some of the other people in this case, because my client actually does have at least a partially illegal sentence, because there's a Court of Appeals opinion that says that in-state burglary was
And
wrongly.
I'm struck with it that this is one that actually made the correct objection
Right.
prior to some of these cases and said, no, it shouldn't be categorized as a person felony. I kind of remarked on.
Right. And so, I mean, when I was thinking about this in the context of listening to these questions yesterday at argument, my immediate concern was that, at least in part, based on his sentence that's associated with that particular person felony that's already been overturned by the Court of Appeals, that the petition from the state was denied by this court and is not subject of this today. He's got potentially that ability to go forward, but only on that part of the sentence. And so, I mean, he's, I don't have any particular insight as to whether or not, he's looking at that as an option. But I still think that, certainly at least part of that has been met in this case, whereas on this particular part of the sentencing, it hasn't. So I think it is in a slightly different position than some of those questions yesterday. Ultimately, even if this court determines that it's not technically moot, I think in particular it's problematic in this case and meets the exceptions to mootness for the simple fact that this is a Court of Appeals decision that came out before Wettrick and affirmatively declares that Colorado felony should be counted as a person felony, with not just in my client's case, but for the purposes of anyone else who's looking at that. And one of the points that I kind of wanted to make this morning, which I know the court knows, but that is worth pointing out, is that in this day and age, the difference between an unpublished Court of Appeals opinion and a published one is really a matter of degree as opposed to application. I mean, when I first started practicing, which I feel like wasn't all that long ago, but apparently was, you couldn't get Court of Appeals opinions that were unpublished without going to great lengths unless you were a party to the case. And now it seems like, you know, with the click of your fingers, all that comes up on Westlaw is unpublished case after unpublished case. And even if they're not precedential, they're still very probative, and they're used, you know, throughout the state far more frequently than we ever did even just 10 years ago. And so having this published Court of Appeals opinion out there, not only does it potentially affect my client if he ever does end up going back through and he's going to have to potentially relitigate, if he's even able to, the same issue, but it also is out there for lawyers who are not maybe as appellate savvy.
But that's just sort of a so what kind of thing. I mean, the counsel will be able to say, look at Wettrich and go from there. And if the court's wrong in the way it analyzes it, then so be it. But you've got that venue. Why do we need to correct something that might happen later?
I think that so what attitude is interesting from a lawyer's perspective. I think the problem is in the meantime somebody's sitting in prison, either pre-trial while they're trying to work this stuff out, or post-trial while they're trying to litigate the corrections to this sentence. And I think particularly when you've got a published or unpublished Court of Appeals opinion that says this particular kind of conviction is a person felony, even if, and that the Kansas Supreme Court had an opportunity to correct that after Wettrich and didn't, I think it's not unlikely that a prosecutor or a district court might read that incorrectly and sentence somebody based on that crime, even if it's a unpublished Court of Appeals opinion. So I think even if it's not technically moot, which obviously our first argument is that it's not moot, but even if it's not technically moot, I think we clearly meet this public exception of repetition and evading review, especially if you have a short sentence, then you run the risk of doing exactly what we did here, which is that we've litigated this issue and then the person's already served their sentence. So we would certainly ask that this court retain it on mootness and get to the merits of the issue. Of course, getting into the merits of the issue, then we also need to talk about the retroactivity argument by the state on the correction of legal sentence, which this court has already discussed a little bit this morning. I would just echo my fellow counsels from the Appellate Defender Office's statements from the last case, which is that we don't think Wettrich was a change in the law, and if it was a change in the law, we think it was a substantive. We think the amendments to the statute were a substantive change that we're actively cutting off.
Let me ask you
rights.
this. Do you like those arguments better than just saying, look at the statute, they didn't say retroactivity, they know how to say retroactivity, and so we're done?
I think that's the most
Why isn't that just the simplest answer?
obvious. Well, and
Rather than going around, it's not really a change of law, or that the legislature, you know what the legislature intended by passing that statute, and nobody can pretend that they don't know what was meant.
I don't know that
The
I
question
ever.
is whether, like Justice Johnson says, knowing that, why the world they didn't just put a sentence in there that says, hey, it's retroactive.
I'm not going to purport to ever really know what the legislature is thinking, because certainly some of it defies explanation from time to time. But I think Justice Johnson's point is a valid one, that they obviously know how to do this. My case was the lesser included offenses on felony murder, and that day hurt a little bit when they went back and corrected that with the retroactivity. So they certainly know how to do it correctly, and they didn't do so. So I think if that's the court's preference, I would not disagree with that.
I want one question about the burden of proof, which is where you started your argument. It seems to me that the better way to look at this is, you asked in your brief for a change of sentence.
Mm-hmm.
We can't do that for the guy
Right.
because he's gone. So the state points that out, saying this is the relief they asked for. Can't do it, case is moot. Seems like that's they met a prima facie showing. So why wouldn't the burden then shift to the defendant to come forward and say, wait a minute, there are things out here that would mean why it shouldn't be moot, or that it's not moot, and bring forward that burden. I'm thinking particularly of the firearm issue, even though I don't think you raised it. I
No.
get them confused, but I don't think you raised it.
Right.
But, you know, Justice Johnson yesterday said, wait a minute, this is timed from the day you get out of jail. There's nothing about... I don't think the state should have to do that analysis. I think you should have to come in and say, we want to possess a firearm and we have the ability to but for this, we would have our gun and be happy. Or in your case, legal malpractice, or this, what you called a res judicata thing, but
Right.
it's really collateral estoppel.
Yeah, collateral estoppel.
But then you have the burden to come forward and say, these are real consequences, and not put it on him. On the state, I should say.
And I think to a certain extent, I mean, there is, in every case where you're arguing about to this specific client, how is this going to work? I mean, there will automatically be some back and forth. I think the real question here, and I think sort of the underlying assumption to the beginning of your question, is that the relief that we've asked for is sentencing relief. And I mean, that is the relief that traditionally is asked for when you have a motion to correct the legal sentence. I mean, but
it's at the bottom of your Court of Appeals brief, because I
Right.
went and looked at it.
And yes, and this was another question that I started thinking about yesterday in the context of this court's arguments, is that it's traditionally, I think there probably hasn't been that much, because you're usually talking about sending it back for resentencing. And in this case, actually, I mean, with the Court of Appeals opinion, it's already been sent at least partially back for a resentencing, a new probation revocation hearing in this case. I think it's thrown out there as, well, of course, that's what we're asking for. And at the time that we filed the Court of Appeals brief, my client was still in prison.
Right.
So that wasn't an inaccurate request. It's just that I think certainly going forward, looking at the specific requests that we're, the specific relief that we're requesting, maybe we do need to spend a lot more time thinking about having a more broad...
Isn't what you're really seeking now that the sentence is complete is a change in criminal history?
It's a correction of the criminal history.
Correction of criminal history.
Right.
And how
An amended
is there a
PSI.
way to do that short of resentencing?
Well, and that's...
These questions kind of came up after we had our cases yesterday, but in my mind, is there a way to correct a criminal history without a resentencing?
I would
What
like...
would be the mechanism? Because that's really what you're seeking. Now that the sentence is complete, isn't that what you want?
Right. Yes. And I think it was Justice Johnson that initially asked that question yesterday about
Right.
what actually was the remedy. And I think in this situation, I mean, what ideally would happen for us would be a correction of the criminal history in the PSI, like an amended PSI being filed.
And
then
what's the mechanism for that?
what happens at that point? Well, I think the mechanism for that would be that the court can order that something like that be done. I don't think it's a whole lot different than those situations where, for instance, this court's declared that a portion of the sentence with the no contact orders is inappropriate, and then just by a nunc pro tunc, it's required to essentially strike that or fix that in the journal entry. I mean, I think the court could probably fashion some kind of remedy for that. The real problem, I think, is that, and obviously we'd like to avoid a resentencing to avoid some of the collateral consequences that come up at a resentencing, like if the client's gotten new convictions in the meantime or something
Right,
else.
there's lots of things.
Yeah, I mean, that's definitely a concern. But I think if you're talking about just the criminal history score, you might be able to order an amended PSI essentially. Now, if the court decides that the only real remedy is to go back and do a resentencing, then that sort of opens the door to, if something different happens below at an official resentencing.
Hey, be careful what you ask for.
Right, you have to be careful what you ask for. And there's the potential of having to litigate some kind of vindictive sentencing issue if it's not related to something like a new crime or something like that.
Going back
It's
to
definitely a danger, I acknowledge.
Going back to Justice Rosen's point, where is the criminal history? Where was it? What hearing is it established? Where is it established?
It's established at the sentencing hearing.
I mean, that is it, right?
Well,
And you could go back perhaps and ask for a resentencing, but in essence, you're trying to fine tune the criminal history. I mean, it's still the mechanism would be a motion to correct a legal sentence, wouldn't it?
Well, yes, but that's because what that particular statute's called, I guess,
Right.
is that, I mean, I
But there's a
hesitate-
lot going on in a sentencing other than just
Right.
go to jail, probation, that type of thing.
Yes, that is correct.
That's
And-
Or you-
the result.
And like I said, in this specific case, I think part of the problem is that we've already sort of got this partial remand for a resentencing, probation, revocation, correction that's hanging out there that probably complicates things even more in this case.
Another way to look at it, which I think I'm alone on the court, is that a motion to correct an illegal sentence asks for a correction of the sentence. It does not ask for a resentencing. And 223504 does not say you can have a resentencing at any time. It says you can have a correction at any time. And if we looked at it that way, then a motion to correct an illegal sentence would only permit the correction of that which was illegal. And that would be the criminal history score. So you could ask, if we allowed that, you could ask for a correction of that part of the sentence that was illegal, which was the criminal history score, even though the sentence is not amenable to correction.
Even though
But
the
that
sentence
would
is
take some
finesse.
fine tuning of our,
Precision.
yeah,
Precision and-
yeah.
Yeah.
Remand.
Your Honor, if I may have just a few seconds to summarize.
Well, I'd like to
Oh.
interrupt my colleagues and
Sure.
be impertinent and ask a question on my own.
Right.
Do you have a case that says, even though the sentence has been completed, the case is not moot because we want to explore other issues such as the criminal history being corrected, or I want to sue my attorney for malpractice, or I want to be a gun-toting barber, or all the above?
No, Your Honor. That traditionally, I don't think has been a case that I can think of, at least off the top of my head. I mean, I'm hoping this might be it, but I think traditionally, perhaps both parties even have just kind of assumed that the sentence, is what it is. The only thing I can think of that's close to that is actually in Montgomery, this court's talked about the idea that a criminal history score could affect the outcome, but I think in that case, it wasn't, the sentence in that case wasn't moot at that time. So I mean, that is sort of an extra layer, and in that case, the issue was actually a probation disposition, not a sentence. So there was some conversation in Montgomery about that, but I don't think it's a case that I can squarely say, yes, we can move forward on this.
And the flip side of that is the next question. Are you aware of any cases that say once a sentence is complete, the criminal case is over? It's moot.
Yeah, I mean, I think there's certainly been lots of cases where that's been dismissed as moot. Our argument would be that that was erroneous, and that oftentimes I think in those cases perhaps this sort of line of argument wasn't explored fully.
All right, thank you. Any further questions? And I'll give you 30 seconds to wrap up.
Sure. I just wanted to point out, just very quickly in summary, that this is not a situation where this case went on and on and on and then became moot. At the time that the Court of Appeals decision came out, it was pretty obvious, because I think he was only a few months shy of the end of his actual DOC sentence and Wichita work release, that that it was highly unlikely at that point that we were going to be able to get a benefit from the actual sentencing in this case. And so when the state filed its petition, I mean, whatever chance there was pretty much went out the door at that point. And so when we filed our petition, it was with the understanding that moving forward, there probably would not be an actual sentencing benefit. But we made the intentional decision to go forward anyway, because that criminal history score does follow the client. So thank you very much.
All right, thank you, counsel.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'll start off with the mootness issue, as opposing counsel did here this morning, and as this court is aware, as opposing counsel noted, we discussed this to some extent yesterday. My beginning remarks, I would like to start with the burden of proof. I think there's been some question about this from a number of your honors. The best answer that I can give is similar to what I gave yesterday, is essentially that the burden should be on the defendant to come forward with something to say it's not moot, is to point this court to the jurisprudence regarding the burden of production versus the burden of persuasion. And I think here, if the state can produce a prima facie showing that a case is moot, the burden of production to demonstrate why it is not moot must fall on the defendant. And the main reason for that is because the state is never going to know why a defendant feels his case is not moot. There may be conversations with the defense counsel that we're not privy to. There may be actions he's seeking to take in other states that we're not privy to. So it's not possible for us to know every possible gesticulation that a defendant may be going through to try to claim a case is not moot.
I just got a terminology problem. It seems like when someone has a prima facie burden, which you're kind of saying, yeah, the state could take on a prima facie burden. That's the production, and then persuasion is when you try to rebut that.
Correct.
Is that right? Okay, I thought you said production again, and I was confused. Okay.
I may have, and I apologize.
All right, thank you.
Well, speak to what Ms. Cessna spoke to at the very end of her argument, and that is kind of the timing of these things. Here, Mr. Tracy really didn't delay anything. It was pretty contemporaneous with his denial of his probation, raising the exact issue that is before us, and that is the I think it's a Colorado burglary was improperly designated as a person crime. And there was nothing that he did to delay this, and it's on track to be dealt with. And it's only because he had a shorter sentence that he's denied the relief he's seeking, or at least the opportunity to even argue it. This isn't something that's 5 years old or 10 years old, brings it, can file at any time, and it's 10 years ago that the sentence happened. This is really almost within the case. And there's something that seems different about that than some of the cases we've previously heard on mootness. Can you address kind of the timing, and just the equity of all that here it happens, and he gets some of the relief he believes he's entitled to, and he's on the last stretch here, you're done, you're out.
Well, I guess I would start by saying I don't know that he actually gets any of the relief he was seeking. He's completed his entire sentence. Revisiting his probation revocation is irrelevant at this point. Revisiting his criminal history score is also irrelevant at this point under the facts of this particular case. The timing issue, the state does take
So if you have a short sentence, basically you're really not entitled to relief on this question, because
No.
most likely if you get a 12-month sentence, there's no way to get relief.
That's not correct. The avenue for relief would be the avenue that the defendant, Mr. Dickey, found in Dickey 1. He could have taken a direct appeal of his sentence. He could have made the same arguments that Dickey 1 did. He did not. The problem that the state is now facing is the confusing and frankly overbroad and erroneous language in Dickey 2 that there are apparently no procedural bars at issue anymore. So this defendant, he could have sought relief akin to Dickey 1. He could have even asked for an appeal bond while that issue was litigated, which could have been a meritorious claim simply because of the fact he had a very short sentence. He could have asked for an expedited appeal to raising the issues of Dickey 1. So he's not cut off from all avenues relief. None of these individuals were. They all could have been Dickey 1. They weren't. Jeff Dickey was Dickey 1.
No, go ahead.
No, I was going to ask a little different question,
fine.
but go ahead.
No, I'm okay.
It sounded like you were taking some exception, I think you used the word unfortunate language in Dickey 2.
Right.
Could you tell me what language that is?
I didn't bring Dickey 2 up to the podium, but I can refer the court to basically the language is that because the defendant's constitutional claim resulted in a statutory, or in what this court found to be a statutory error in his sentence, that all of the state's procedural bar arguments basically fade into irrelevance. And the state simply doesn't.
Because of 3504 at any time.
Because of the any time. It was the reading of any time to eliminate not just the time requirements for these defendants, but to also basically preclude any procedural bars that existed, res judicata, waiver, abandonment, etc., which are issues that we briefed initially in this case.
Would you be referring to the language that says the question of the proper classification of the prior claim purely as a matter of statutory law? Is that what you're saying?
I think that that's part of it. And to answer your honor directly, I think Dickey 2 is wrongly decided. I think that the issue is, and always has been in this series of cases, a constitutional claim based on Apprendi, and I think it was Justice Gardner pointed out in one of her dissents in the Court of Appeals that.
Do you really want to make that argument? In other words, do you want to open up a motion to correct an illegal sentence to constitutional claims?
No.
So do you think Dickey 1 was also wrongly decided?
I think that.
I mean, if you're saying, hey, this is a constitutional claim, don't you also have to say Dickey 1 was wrongly decided?
I think the state has been opposed to opening up illegal sentence claims to include constitutional claims for some time. But beginning with Neal, we've been told that that's no longer the case, that constitutional claims apparently can be bootstrapped and shoehorned into 223504. It's further erosion of what the any time
Dickey 2 expressly said that that's not the case. It expressly reaffirmed the rule that you cannot raise a constitutional claim in a motion to correct an illegal sentence.
Except that Dickey 2's claim is the claim in Dickey 2 was expressly based on Apprendi. It was not purely based on the statutory language, and it cannot have been, because our statutes at the time that Mr.
I'm
Dickey
just struggling to understand why you want this court to revisit Dickey 2 when it expressly acknowledged the rule that you also want.
Well, because while acknowledging the rule, it failed to apply it. Because the statutes that were in place at the time when these defendants, including Mr. Tracy, were sentenced, expressly authorized the factual findings. They expressly authorized it. The only bar, literally, the only thing that could have precluded the application of the statutes is a constitutional Apprendi claim.
But we can't interpret a statute unconstitutionally.
I'm sorry? You can interpret a statute, find a statute to be unconstitutional.
Well, we can find it unconstitutional, but if we are construing a statute, if there's some ambiguity and we're construing, one of our options isn't to construe and apply it unconstitutionally, is it?
No, I don't think that this court could reach an unconstitutional result.
I mean, I'll call it the tap dance of Dickey 2, it seems to me, was, and I think the language in the case is actually constitutional overlay, as Justice Johnson refers to it, or is referring to. We said there's a mechanism in the statute for making this fact-finding, but at the time Dickey's sentence became final, I mean, the U.S. Supreme Court had said that that mechanism is unconstitutional. And so we said, as a matter of state statutory law, his prior crimes were misclassified.
And I think this gets to, I guess, the core of the question of whether or not what our statutes had codified was actual fact-finding. And the state's position in these cases has and remains that the comparability analysis that was authorized was not fact-finding. It was simply comparing the elements of the statutes. I think any reasonable person can look at one statute, like for instance a statute from Colorado, and compare the burglary statute in this case, compare it to Kansas's burglary statute and say those are pretty much the same. Those are comparable.
Well, maybe you can, if you want to get to the merits. Here they said, well, intent doesn't make any difference, and I don't understand that, because if Mr. Tracy had entered the non-dwelling structure in Colorado with intent to commit vandalism, then the comparable crime in Kansas is criminal trespass. It's not a burglary, right? And so, I mean, your intent has to fit into the comparability scenario, which means you have to get in to that factual weeds, unless you strictly apply the elements.
Respectfully, no, Your Honor. That very argument that no, my crime should have been more comparable to a criminal trespass could have been made on state. That argument could have been made on state law grounds at the time of the sentencing, and then the district court would have the discretion to make its legal conclusion. Is it more comparable to this, or is it more comparable to that? Purely as a matter of law. There's no fact finding necessary to engage in that. And to the extent that there are constitutional...
I don't understand that. If Colorado allows any intent, and you're saying the defendant's arguing, well, I only intended to commit vandalism rather than a felony, why doesn't that involve fact finding at the district court level?
In favor of the defendant.
Your Honor's question presupposes one thing, and that is that the defendant is saying, my crime in Colorado was only to do vandalism. He can make that argument, and he can do so by waiving the protections of Apprendi and expressing to the district court, look, in my Colorado case, all I did was go into a home or a building, and I went in there to do vandalism. And here's the record, here are my statements. He could even testify to that fact, and perhaps the state could not even rebut that testimony. But these are claims that are properly made statutorily at the time. And so that's where I think we've gone far too far afield in Dickey 1 and 2 with the construction of at any time.
I think I may have gotten us on this sidetrack. If you could summarize for us why you think this is moot.
Sure. This defendant has completed both the imprisonment and the post-release periods of supervision on his case. The case is moot. There's no point in having him go back to the district court and potentially be subject, as my friend argued yesterday, that what is our procedure? What are the practical implications here? Are we going to have an order to appear and then arrest somebody and hold them on a bond for a case that's completely finished? That seems entirely unreasonable to me. I did want to touch on one thing that came up yesterday, and I think that it is a further level of complication here in the mootness arena. Justice Beyer, you asked about the Lehman case yesterday. And in that case, this court found, and it's syllabus 5 and the language is echoed in the opinion itself, that if once a defendant has completed serving their sentence, including the period of post-release, even if that sentence was illegal, that the district courts lack jurisdiction. So this was Justice Beyer and Justice Stiegel's question yesterday. So there's an additional layer here, and I don't know necessarily where that goes. Mootness has always been a court doctrine for efficiency, but jurisdiction, this court has a duty to question on its own accord, and that's another problem here. I think that there's a valid question of jurisdiction. I think there's absolutely no question regarding mootness, that this case is moot. And to that end, as I've already touched on the speculation just a little bit, but what I heard argued here today is something that's odd. I mean, we're talking about correcting some kind of a correction of an illegal sentence that's not a motion to correct a sentence. I don't necessarily know what that means. A motion to correct an illegal sentence that challenges your criminal history score, the relief you get is a resentencing, because our statutes require that if your criminal history score was illegal, you are to be resentenced, and our statutes provide that we go through that process again, and that allows us to include subsequent convictions and things that have occurred since. So again, this is kind of toes on the practical effects and the reality of the situation here.
You avoid those possibilities by filing a declaratory judgment action?
I think that's possible. And again, I know that was something that was presented, again yesterday, but there are potential remedies here that are outside of this case, this specific criminal case, to address any of these collateral consequences, which may or may not ever occur, that are purely speculative. I see that I'm out of time. If this court has no further questions, I would respectfully request that this case be, if this court finds that it lacks jurisdiction, that the case be dismissed for lack of jurisdiction. And I would absolutely request that this case be dismissed as moot. Seeing no further questions, thank you all for your time.
All right, thank you, counsel.
May it please the court, just to respond to a couple of the things that Mr. Gillette talked about. I think when we start to get into the weeds of where we were going here for a little bit during his statements, it becomes pretty obvious that part of the problem here is that I don't know that the state fully understands the extent of their own argument, and that when you start getting into, well, Dickey was wrongly decided and Wettrick was wrongly decided, then we're talking about the court having to declare statutes unconstitutional, and then at that point there's no mechanism to even count these criminal history scores. I think part of the problem here is that the state doesn't like to lose, and that was, I think, evident from the testimony at the changes for the in front of the legislature for the changes to the motion to correct the legal sentence statute, and part of the problem is now we're dealing with sort of this fallout of that the state doesn't like to lose these cases. And my response, I guess, is that if this court comes out on these sets of cases and says that somebody like Mr. Tracy, who essentially did all the right things at the right time and is just because of the extent of the length of time that this appeal has taken, is rendered moot, I think what you're going to end up seeing is a whole lot more motions to expedite and things like that get filed immediately, even when the sentence hasn't been expired yet, because of course that's when you're still in time to do so. And I'm not really sure what all of the extent of the fallout of that will be, but I'm sure it will be more than what the state has probably thought about at this point. And so I would ask this court respectfully, even though obviously initially, because this came up as a motion to correct a legal sentence and he was under sentence at the time, we initially were asking for the correction of his actual sentence, that at this point what we're asking for is just the correction of his criminal history score. Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.